In the Trump immunity case at the U.S. Supreme Court today, Justice Samuel Alito raised the hypothetical question of whether a president would be protected by immunity if he uses the U.S. military SEAL Team 6 to assassinate an individual. The court digging into the Trump team's argument that a president can't be criminally prosecuted for official acts. And joining me now, the conservative lawyer George Conway, a very vocal Trump critic who's now a major donor to President Biden's reelection campaign. George, thanks very much for joining us.
Thanks for having me.
Let's talk about these historic oral arguments before the Supreme Court today. If the Supreme Court were to decide that presidents have immunity for official acts, but not for private acts, what would that mean for Trump?
I don't think it necessarily means that he wins. I don't think he's going to win as broadly the broad immunity that he's been arguing, which is essentially that he could do anything that, the SEAL Team 6 the SEAL Team 6 hypothetical we've been talking about, the coup hypothetical that was talked about. I don't think he's going to win that kind of broad official immunity. I think the reason why the Supreme Court took this case, and it is understandable. I would have preferred they not take the case. I would have preferred that this case go immediately to trial. But there is the question of where do you draw the line? There could be abusive prosecutions in the future. I think Justice Gorsuch said, I'm not worried about this case, I'm worried about the future case. And I think a lot of people were very upset about how much of the discussion today was not about the actual case before the court, but from hypothetical cases that could happen in the future, but might not ever happen. But before they get angry at the court for asking those questions, they have to think about the fact that, well, suppose on January 20th, 2025, a man takes over in the White House who wants to seek retribution on his political enemies and who appoints an attorney general who would bring prosecutions against people who opposed this president in the past. These are legitimate questions, and they are actually real questions to be asked. And it's sort of like, I think of it as a variant on the old expression that you hear in the law of hard cases make bad law. Well, bad people make hard law. And that's the thing that the Supreme Court is struggling with is I don't think there's a single vote on this court that's going to allow him not to be prosecuted for what he did in trying to stay in office. But they do appreciate, and that's what the discussion was all about, like, all right, but aren't there some circumstances where the prosecutorial power could be abused for political purposes against the former president? And that's a legitimate concern. It's just not one that's actually occurring in this case.
What's the worst case scenario if this case were delayed until after the November election?
Well, I think there's actually there's some silver linings in here for people who want to see a more immediate imposition of justice. I mean, here's the way I see it. The Supreme Court, at the worst, at the best, I think that the case is not going to go to trial until September 17, because I think the court's going to end up having to take the rest of the term through the end of June. And then if you add 81 days, which is what people are saying how long it would be before a trial that Judge Chutkan has already indicated she would give, you could end up with a trial in the middle of the campaign from September, in September and October. You just wouldn't get a verdict by Election Day. Now, people are talking about this possibility of a remand for further proceedings before a trial. Well, the problem for Trump is that, well, if I'm Judge Chutkan and I got to conduct some kind of fact-finding or a hearing, I'm going to say, fine, let's do this in July, and you could end up having a hearing that ends up being a mini trial, airing all the evidence or a lot of the evidence that we would see at a trial. And I think that would serve the public good, actually, even if we don't get to a verdict before the election.
In Trump's so-called hush money trial in New York, David Pecker, the former publisher of the National Enquirer, testified today that he told Michael Cohen, the ex-president's former lawyer and fixer back in 2018, and I'm quoting Pecker, "We committed a campaign violation." How revealing is that?
Oh, it's completely revealing, and it's a fact. I mean, this is why Pecker is such a powerful witness, because basically what happened with Stormy Daniels was set in motion by the original scheme that was set up using the National Enquirer, where the National Enquirer would essentially be used to pay off people, to buy off people so that negative stories wouldn't be published about Donald Trump. And then AMI had to step out of it because Trump wasn't paying them, or because the lawyers at AMI decided no. But they did for the same purpose as the original payments through AMI. It was the same purpose that Cohen financed himself and then got reimbursed for the payments of Stormy Daniels. It was to affect the election. It's damning testimony, because the fact that there is a campaign violation or finding that there is a campaign finance violation is what kicks up the business records charge from a misdemeanor to a felony. And that's what could get Donald Trump jail time.
Potentially. Thanks so much for coming in, George Conway. Appreciate your expertise.
Thank you.
Thank you.